to objectively look at this issue of the executive order of the law council issued by the president of the Uganda Law Society and the position of the law, the Uganda Law Society Act, you really need to look backward. You cannot understand this problem without looking at what the Constituent Assembly said in 1995. So what did the Constituent Assembly say in 1995? That is the old Article 275. And I'll read it verbatim because it is the foundation for what we are going to discuss. The first president elected under this constitution may, within 12 months after assuming office as president, by statutory instrument, make such provision as may appear necessary for repealing, modifying, adding, or adopting any law for bringing it into conformity with this constitution, or otherwise giving effect to the constitution. The Constituent Assembly told the president that in your first year, your first 12 months, you must make provision for bringing all existing laws into conformity with this new thing we have now brought up, or give effect to this constitution. In other words, the Constituent Assembly recognized that it was coming into force as a new constitution in 1995, but it was contradicting many of the colonial laws, many of the laws we had been having over the previous century. Because remember, the first laws in this country began in 1900. So 1995, 100 years later, the Constituent Assembly is saying, look here, we are aware that we are bringing in something very new for Uganda, and it might contradict many laws. So you, President, in the first 1 year, make sure that those laws are brought into conformity, they are adopted, they are repealed, they are modified so that they run into tandem with this constitution. If you do, and I'm not blaming the president for not having done it so, because he must be advised to do so. The president doesn't do everything on his own. It has been incumbent upon the attorney generals who have held that office since 1996 to study all these laws which exist and bring them into conformity with the Constitution. Unfortunately, they didn't. And now if you look, what I'm looking at is the original Constitution, which has that provision. If you look in today's Constitution, what will you find? That was Article 275. If you look in today's Constitution, where there is it says repealed. In other words, Parliament, during one of these many amendments they have been doing, they repealed the requirement to bring all our laws in conformity with the Constitution. Instead of implementing what the Constituent Assembly did, Parliament instead repealed it. No, let's continue with those contradictory laws. That's where now the problem is between the president of the Uganda Law Society and the Attorney General. The Attorney General is saying, look here, the Uganda Law Society Act is very clear. It makes me a member of that council, and I must be there. It's an act of parliament. The Attorney General and the Solicitor General said. That is their side. Then what is Ssemakadde saying? Now Ssemakadde for him is saying, you repealed the law which required you to amend, to modify the Uganda Law Society Act to bring it into conformity with the Constitution. And because you repealed it, me now, Ssemakadde, President Uganda Law Society, I am now going to rely on Article 274. Because you repealed 275 instead of doing your work, for me now I'm going to rely on Article 274, which says that all existing laws, including the Uganda Law Society Act, and let me read it so that you can understand also his side. You've understood the side of the Attorney General. He's saying the law is very clear. I'm a member and I'll go there. Now Ssemakadde is saying, and this is what he's relying on, the operation of the existing law after the coming into force of this Constitution shall not be affected by the coming into force of this Constitution. The law shall continue, but the existing law shall be construed with such modifications, adaptations, qualifications, and exceptions to bring it into conformity with this Constitution. So now the President of the Uganda Law Society, because you, the President, the government of Uganda, failed, instead of implementing Article 275, you instead repealed it. Now for me, I'm going to rely on 274, which allows, which says you must look at the Uganda Law Society Act in conformity. You must look at it in conformity with the Constitution. Therefore, for me, Isaac Ssemakadde, what I have done is now I am looking at the Uganda Law Society Act and issuing an executive order to bring it into conformity with the Constitution. The whole thing is up there with the Constitution. So that is what he's now saying. That's why he's debating himself, that I have issued this executive order under Article 274. Further, what he argues, I'm just putting the case of the Attorney General and the case of Ssemakadde. I've not yet made conclusions. So he goes further and he says that Article 1 of the Constitution allows him to do so. Because I'll read it again. He says, all organs and agencies of the state, all citizens, organizations, and other bodies and persons in applying or interpreting the Constitution or any other law and implementing any policy decision for the establishment and promotion of a just and free democratic society shall be guided by these objectives, the Constitution. So what is he saying? He's saying, look here, all citizens, even the government, all of us can apply and interpret the law. So he says, I have interpreted the Law Society Act against taking into account the interpreting Article 274, and I've come to the conclusion that the Attorney General and the Solicitor General cannot sit on the council. at this site. And therefore have issued an executive order expelling them. So you can see where he's coming from. He's now relying on the Constitution and the power of all of us to interpret and apply the Constitution. That is his side. So these are and others have said on the other side, the Attorney General is saying, look here, the Act of Parliament is very clear. It makes him a member of that council. You can't just wake up Ssemakadde without amending the Act of Parliament and expel me. That is what the Attorney General is saying. So it is not as simple as it appears on the face of it. It is not as simple as it appears on the face of it. When Ssemakadde was saying these things before he was elected, before the executive order, we all said, hey, look here. Where is he getting himself from that? But now when he's in office and this executive order and decides these laws, everybody should pull back and say, oh, let's look at them and see what is what. And at the basis of Ssemakadde's argument is that the Uganda Law Society Act, which was passed in 1956, that is 70 years ago. He's saying, look here, that law, when the Constitution was passed, saying it must be brought into conformity with existing Constitution, you cannot allow the Attorney General and Solicitor General to sit on in the council, because then you remove the independence of the Uganda Law Society. That presently the Uganda Law Society must be independent in order to fulfill its objectives. And I see a point on that. Now this is my view. I see a point in what he's saying, because under national objectives and directive principles of state policy, policy number Roman 2:6 says civic organizations shall retain their autonomy in pursuit of their declared objectives. So how then can Uganda Law Society be independent? How can it be autonomous when the executive arm of government is sitting in that civic organization? It makes sense. It makes sense. So when we are interrogating this issue, we should be objective about it. We should be objective and agree that the 1995 Constitution brought into a new regime, a new legal regime, which required that all these laws for the last 95 years should be modified to bring it into account with that. There was nothing wrong in 1956 when the Uganda Law Society was put there. There was nothing wrong with the Attorney General sitting in the Uganda Law Society. All power then was fused into the governor. Executive, legislative, and judicial power was fused into the governor. He was to implement law. He could even make a judicial decision, although the courts were there. But the 1995 Constitution does not allow that. It does not allow you to fuse the executive power with the legislative power, with the judicial power. So it was necessary to now look at this 1956 Uganda Law Society Act and bring it in conformity with the new arrangement where the executive does not fuse with civic organization, with the legislature, with the executive. And that's why the Constituent Assembly was specific when it passed it to 75. And it said, in the first 12 months, you must bring all these laws in conformity with the Constitution. Instead, we repealed it. That's where we must come from to examine this apparent conflict between the Attorney General and the Uganda Law Society through their president. So what is the way forward? What's the way forward? The way forward is that both the Uganda Law Society and the Attorney General should go back on the drawing board and implement the directive of the Constituent Assembly in 1995. Because this does not only apply to the Uganda Law Society. It does not only apply to the Uganda Law Society Act. It applies to so many laws which are still there, but which are not in conformity. They have not been modified to bring them in line with the Constitution. That's where the conflict is, a simple thing. So I would expect now that the Attorney General and the President of the Uganda Law Society should now get on the same table and sit and say, there has been a failure since 1996 when the President did not, in the first year, do what he was supposed to do. Let's do it. Because both the Attorney General and the Uganda Law Society, both of them have a mandate to advise government under the Uganda Law Society Act, Section 3. So if the Constitution says Attorney General advise government, and the Uganda Law Society says Uganda Law Society advise government on matters of the law, the only common thing now is for both of them to come on the same table and do what they were told to do quarter of a century ago, which they have not done. All right, questions?
Okay, we got a
For me to come to the conclusion on whether President Ssemakadde is being motivated by personal interest because he has a conflict with the Attorney General, I just simply look at the law. And if the law tells me Ssemakadde has a point, then I cannot see there is a conflict of interest. If he has no point, if I cannot discern a legal point on his part, then I'll start thinking about what you are saying about personal interest. But for me, what I have seen and where I see the problem came from, I can't say this is a question of personal interest. Maybe he has it, but it is covered by the law, so it must drop by the wayside. His role, you cannot understand the role of the Attorney General today without looking at the context of when that law was made. And when was the law made? The Uganda Law Society Act was made on the 27th of November, 1956. That is when it came into force. That's when it commenced. So, look at the role of the Attorney General in 1956 and look at his role today. Are they the same role? Huh? Are they the same role? So for me, what I would expect now the Attorney General to do is to say, yes, I'm supposed to sit on the Uganda Law Society Council. Under the law, I have that right. But looking at the past 70 years when this law has been in existence, is it still right for me to go and sit there? Can I examine this law carefully and see whether really it is right for me to sit there? Because even the Attorney General himself on his own can say, I have studied the law, I have studied the Constitution, and I have seen that although the role of the Attorney General was necessary in 1956, when executive, legislative, and some judicial powers were fused in the governor, who is now the president, it is no longer the position, though maybe I should not be there. It is a personal, it is an official decision of the Attorney General. And my advice would be, look at the law and determine yourself. Look at the Constitution, look at the law, and determine yourself, by yourself. Do you think you should sit on this civic organization where sometimes you may disagree on points of law with these lawyers? Because every day lawyers we are disagreeing with the Attorney General in court. Should you sit there? Because my client walks in here, he sues the Attorney General, because the Attorney General represents the government. Attorney General comes and says, my client is wrong, the government is right. We make submissions which are opposed. Should the Attorney General have a lot of say in the way I run my affairs in the Uganda Law Society? Put another way. Put it another way. Can we, as the Uganda Law Society now, sit and pass a resolution to say that because the Uganda Law Society Act allows us to advise government on legal matters, President Ssemakadde should start sitting in cabinet whenever legal issues are raised, so that together with the Attorney General, they can help government. It's the law. It says Uganda Law Society. Okay? Article 3, assist government in all matters affecting legislation and administration of law in Uganda. Administration and practice of law, both administration of the law and the practice of the law. So should we now say that because the Uganda Law Society is supposed to assist the government, President Ssemakadde should be sitting in a cabinet to advise the government on issues of law? Clearly not, because we need that separation of the executive from civic organizations. We can't have a civic organization sitting in the cabinet. So why should the cabinet sit in some? Precisely, that's where the point we are now talking about. Why this law should be brought into conformity with the modern constitution. The Uganda Law Society, under this law, should assist the government in matters of law. And he made it again. To assist the government and the courts in all matters affecting legislation. All matters affecting laws, the Uganda Law Society should assist government. So why shouldn't we have a representative in government? It would be wrong for us to say we should go and advise government on matters of law. That's why this Uganda Law Society Act must be brought in, modified, must be brought in conformity with modern thinking. It is not 1956. This is 2024. Very good question. Repealing an article in the Constitution which required to bring all these laws in conformity with the Constitution, creates a contradiction. It leaves laws which are contradictory to the Constitution on the law books. It does so. So it was a grave failure. Before they repealed it, it was a grave failure by the then attorneys generals, not to assist the president and bring all our laws in conformity. It was a grave failure. And it was escapism. It was abdication of duty. To, instead of doing it, repeal it. That was the grave dereliction of duty. The Constitution tells you to do something, and instead of doing it, you run away.
With the case Ssemakadde, it was like, I filed a case in court, constitutional court, on the issue of the Attorney General and other members of the Attorney General's office. Then, before he came up with that document, he issued casing away the Attorney General before the case is in court.
I have not seen that case. I don't know whether what you are saying is the position.
That is what he said.
But if it is the position that there is a pending case in the Constitutional Court concerning the same issue, then obviously we should allow the court to express itself on that matter, because then the matter becomes sub judice. If you issue an executive order when the matter is pending in court, haven't you already made a decision about the matter? What you asked for in court, you've already decided. So if that was done, I would expect really that then the Uganda Law Society should await the outcome of that case.